Good morning. Are you Tasia One Mac?
Yes, ma'am.
And this is cause numbers 24 DCCR 1046 and then 26 DCCR 0085 and 0086. Mr. Mack is charged with criminally negligent homicide. And then those last two are both bell jumping and failure to appears. Mr. Smith, what is the announcement?
We signed.
Oh, yep.
Rejection.
There it is. Sorry, they were just coming through. Let me go through then. All right, Mr. Mack. In cause number 24, DCCR 1046, you're charged with the state jail felony offense of criminally negligent homicide, and that's from March 10th of 2024. And what that means, sir, is that if you go to trial and you're found guilty in that case, the range of punishment would be between 6 months and up to 2 years in state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 26, DCCR 0085, you're charged with a third-degree felony offense of bell jumping and failure to appear from December 15th of 2025. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And then finally, in cause number 26, DCCR 0086, you're also charged with a third-degree felony offense of bell jumping, and that's from January 5th of 2026. Same thing, if you're found guilty in that case, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
In each of those cases, I have here on the tablet plea bargain rejections that you've signed with Mr. Smith that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty for a 2-year term in the state jail prison on that state jail case, and then 5-year terms on the other 2 bell jumping cases, all to run concurrently.
This is a pivotal moment in the hearing. By rejecting the plea offer, the defendant is choosing to continue through the legal process instead of accepting an agreed resolution. The judge's role here is to ensure that this decision is made knowingly and with a full understanding of the possible consequences.
Has everything discovery been, you've gotten everything you need, Mr. or everything they have as far as you know?
Yeah, Your Honor. However, just to this court will know, due to my hospitalization, I truly believe that these cases can be moved if we can get an offer of probation. That is not the case at the moment, but that's where we're at. This is the first offender. He's eligible for probation from a jury. Right now, Mr. Coleman is only recommending print time.
Do you know, Mr. Nichols, who is this going to be yours, or are you just covering today?
I don't know who ultimately it's going to be assigned to a judge. I know, it's a homicide case, so I wouldn't expect that part of the offer to change.
Well, except though that the witnesses are going to testify that the shooting is.
Well, that's all between y'all. I don't need to
Okay.
know what all that is.
Okay.
At this point, what I'm going to do is put it on the trial docket.
Okay.
Obviously, if something changes between now and then, I'd rather take care of it well before. So whoever gets assigned to the case, or if Mr. Coleman keeps the case, but either way, if something changes, then y'all let me know. We'll move the case up. Otherwise, we'll take a look at it again on the pretrial date, and then after that, we'll get set for trial.
Thank
Or we'll set up for trial now, but we'll discuss it again in pretrial.
Thank you.
All right,
Thank
you
you.
go back with the bailiff.
Okay.
Here's Samuel Harmon.
Yes, ma'am.
And this is cause number 25 DCCR 1019. Mr. Harmon's charged with aggravated assault with a deadly weapon. And 26 DCCR 0385 charged with assault of a public servant. And what is the announcement?
Yes, he wants to trial. I've conveyed that.
Is the offer, let's see.
Judge, he had previously rejected 15. I re-urged that today.
Okay.
This is their first appearance with this newer charge
Right.
that was indicted in March. And my offer was for them to run concurrent.
So 15 years in each to run concurrent.
Yes, Your Honor.
And so when we've gone over this before, Mr. Harmon, when it was just the one case, that if you're found guilty in either of these cases, the range of punishment would be that of a habitual offender, if that prior criminal history is correct. which means your minimum punishment would be 25 years in prison up to 99 years or life. And you understand that?
Yes.
And you understand the offer of that 15 years is now for both cases to run concurrently or at the same time. You understand? And you want to go forward on both of those cases to trial. Is that correct?
Yes, I was wanting time though to hire an attorney. My people are gonna give me an attorney.
So here's what I'm going to do, just because this has been going on for some time. Obviously, if you get an attorney hired, they can step in at any time. They need to do that as quickly as possible because I'm going to move your cases to the trial docket.
Yes.
Mr. LeBlanc will begin preparation for trial. And if they get someone hired, they'll substitute in. Otherwise, he will go ahead and be prepared when that trial day comes up. Okay.
Okay.
All right.
And Judge, also that second case.
As the hearing continues, the court explains that if multiple convictions occur, the sentences may not necessarily run together. Depending on the circumstances and the judge's decision, they could be served one after another, significantly increasing the overall time.
That the cases could be stacked or run consecutively. If you're given a sentence in one and then they go to trial in the next, then the district attorney's office can ask me, and then it's up to me if those cases are stacked or run at the same time. Do you understand?
Oh, so it would be stacked, not concurrent?
Well, it would be up to me. So it depends on if we go to trial on both of those cases, I would hear all the evidence in both of the cases. And if I decide that whatever sentences you're given in each of those cases, if I think they need to be stacked, then that's up to me. It's not a jury question. It's a court question. Okay. The plea agreement, if you wanted to enter a plea, is negotiated that they would run at the same time if you wanted to take the plea deal.
Oh, okay.
But if it goes to trial, then it becomes up to me if you're found guilty in both. That makes sense?
Yes, ma'am.
Okay. And you want to go to trial?
Yes, ma'am.
All right. We'll get it set for trial. Then you can go back with the bailiff. Good morning, ma'am. Are you Stacy Tyler?
Yes, ma'am.
And this is cause number 26, DCCR 0800. Ms. Tyler is charged with aggravated assault with a deadly weapon. Mr. Lewis, what is the announcement?
Judge, I've been talking with Ms. Tyler, and initially I was thinking it was just some mitigating information I was going to be getting to the state, but there is some that is material to the facts of the offense. And so I am asking for a little more time to do that, especially considering what the offer is from the state and her exposure.
Okay. And do you already have that, or you're waiting to get that from?
I am waiting on a little bit of it.
Okay.
So but it shouldn't take me too long.
Okay. So I'm just going to do a normal reset, Ms. Tyler, so that Mr. Lewis can get all of that information from you or whoever's getting that to him, get that information to Mr. Nichols, and then we'll get an announcement at the next court date. Okay. You can go back with the bailiff. Janae Landerlow, Mr. Lewis.
And we're not going to need her out.
We don't need.
Hold on. Okay.
That's a situation where initially she was set for competency, but they refused to see Dr. Capone.
Mm-hmm.
I've gotten that worked out to where they can come over and see her at the jail. See her here.
Oh, I thought that was
And
already going to get that.
we were trying to see if we can do it next week. I've been talking with Dr. Capone's office.
Okay.
We're trying to see if a date can be known where she can be brought over next week.
Sure.
I need to give Kelly on that.
All right. We'll just reset, a normal reset, and we'll get her brought over next week. We're not in trial next week, so it shouldn't be a problem.
Okay.
Are you Jacoby Murphy?
Yes, ma'am.
And Mr. Parker, will your client read the formal reading of the motion?
It will, Your Honor.
Mr. Murphy, in cause number 23, DCCR 0900, I have a motion to revoke your community supervision. Shows that you were placed on probation April 1st of 2024 for the offense of theft of property, a state jail felony. And that was, could you make sure, hold on, could you check that and make sure it's fine? Sorry. That was a 2-year term that was probated for 5 years. Is that correct?
Yes, ma'am.
And it alleges in this motion that you violated your probation. Count 1 alleges
Judge, I
that,
believe we would abandon that one. That one was not filed.
okay, just that one.
Just that one.
So we'll, count 2 alleges that you committed the offense of driving while license invalid, March 14th of 2026 in Bexar County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department, March 10th of 2026. Is that true or not true?
True.
Count 4 alleges that you failed to gain permission from Jefferson County, to leave the county, and that you were in Bexar County on March 14th of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to immediately report to the probation officer your arrest.
The hearing now shifts from discussing legal options to determining the consequences of admitted probation violations. At this stage, the court considers both the defendant's admissions and the agreed recommendation before announcing its final decision.
Those counts because they're actually true.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Murphy is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that for.
This hearing reminds us that in the courtroom, every decision carries consequences. Whether it's rejecting a plea deal, violating probation, or choosing to fight a case at trial, each choice shapes what happens next. Judges don't simply punish, they weigh accountability, public safety, and whether a defendant has earned another opportunity. In this session, we saw second chances, legal warnings, and the reality that probation is a privilege, not a guarantee. Which decision surprised you the most today? Let us know in the comments below. If you enjoy in-depth courtroom breakdowns and legal analysis, don't forget to like, subscribe, and turn on notifications so you never miss our next case.